Wait. Meeting to order. I see the time as 10:05 a.m. And then I would ask everyone to keep their microphone muted unless they're speaking. And please remember to announce your name when you speak so that your names can be recorded in the records. So at this time, we'll go ahead and move to the roll call with Ms. Delia Luna.
Presiding Officer Bittner, before we move to that next item, I just wanted to give you a formal introduction. We just thank you so much for taking the helm of this board. And I want to say that we do appreciate so much Mr. Dolores Campion's years of service
And then
as
I
our
would ask.
presiding officer. He wasn't able to make this meeting today, but he provided a great framework and big footsteps and for you to follow into, and I know that you are up for that challenge. You were able to assist whenever he was not able to make a meeting, and you just shown in your leadership skills as you all do in your industry, and we want to thank you for taking on this extra duty of being presiding officer. And I forgot to introduce myself, Mary Winston, TDLR.
Thank you for the opportunity. So if we could go ahead, I think, and proceed with the roll call, hopefully we'll have some the other members joining us shortly.
I'm ready to do roll call. Mr. James Graves,
Here.
Dave Yelovic,
I am here.
David Morris. I see him logged in or trying to log in. I can see his name on the screen. Flor Lujan, Suzanne Smith,
I'm here.
Dolores Campion is absent, and Jerry Bittner, presiding officer.
I am present.
We do have a quorum with Mr. Morris there. I see his name. If I'm just hoping that he is completely logged in, but we will have a quorum with him. Mary, may I?
Yes, we will continue to try to get audio for Mr. Morris. It looks like he is muted and he has had some Wi-Fi issues, but he is present. So we'll continue to see if we can get a picture for him, but we will move forward. Oh, there he is. There he
There he
is.
is.
Okay, awesome.
Morris?
Awesome. Okay,
We have
Dale,
a quorum.
proceed.
Okay, we now have enough people to do business, it seems. Let's go ahead and move on to item C, the open government training. And for that, I would turn that over to Mr. Doug Jennings.
Thank you, Chairman Bittner, and thank you, advisory board members and staff. My name is Doug Jennings. I'm Assistant General Counsel here at TDLR. I think you've gotten accustomed to me presenting your open government training, but we have a bit of change of pace today. I'd like to introduce Paula Vela, one of our legal interns who's helping us out in the Office of General Counsel this summer. She'll be delivering your training. She is a first-year law student at South Texas College of Law, and she also has experience working at the Texas Capitol with Representative Mary Ann Perez. We're really happy she decided to spend some time with us this summer, and I'll hand the floor over to her for her training, for your training. Thank you.
Good morning, board. I'm really excited to do this. They gave me this awesome opportunity to help with this training, so I'm going to do my best. If you guys have any questions, please feel free to ask me, and if I can't answer them, Doug will be able to do so. Let me start sharing my screen. You guys see that?
Yes, we can.
Okay. So today we're going to go over three main parts. It's a brief overview on the Open Meetings Act, the Administrative Procedure Act, as well as a Public Information Act. And this is going to go very briefly. If you guys need more information, it's on the notice that was sent out, and I can answer any questions. So first, we're going to go over the Open Meetings Act and the basics of it. So what is the Open Meetings Act and what is its purpose? So this act basically requires meeting of governmental bodies to be open to the public and to have previous public notice of what time, where this meeting will take place, and what the subject of the meeting will be. And the purpose of this act is to make sure that we have an open and transparent government for all. Anyone who wants to be informed can have access to these governmental meetings. And they apply when there is a governmental body in attendance and it discusses public business. And the chapter that discusses this is Chapter 551. So some of the key terms that we should know, first is the quorum. It's a majority of members of the advisory board or the committee that are fixed by the rule or statute. In other words, it's the minimum number of members of a committee that have to be present in order for business to take place. Quorum can be established by a governmental body, which includes an advisory board or a committee. There must be quorum present in order to be able to conduct official business. So if the quorum is not met, the board can still discuss and continue on to the meeting. However, no official actions can be taken during the meeting. An example of this would be as the Texas House of Representatives, which needs 2/3 of its members' presence in order to be able to conduct official business. Another key term that we should know is deliberation or discussion, which is a verbal communication between a quorum of a governmental body or a quorum of a governmental body and another person. It can either be verbal or written communication, and it is concerning an issue that is within the jurisdiction of the governmental body. We also have meetings, and these can occur at any time where there is a quorum that is present and they engage in communication regarding public business. And you can proceed with caution when there is a quorum present and official business is being discussed, because they are subject to the Open Meetings Act. And then we also have notice. So this act requires advance written notice of the date, the time, and the subject of each meeting that is going to be held. And different governmental agencies provide this notice in different formats. However, TDLR provides it in the form of the agenda, which all of you should have been sent out one. And this notice must be filed with the Texas Secretary of State 7 days prior to the meeting. And it must be posted online by TDLR and the Secretary of State. A board or committee may not engage in discussion on a subject that is not included in the agenda. So a question that a lot of people ask is, what about social functions, conventions, and workshops? So can there ever be an informal setting that violates the Open Meetings Act? And the answer is yes. You must keep in mind that a meeting can occur when and wherever a quorum engages in a discussion. So members are free to engage in conversation that is incidental to the event. However, the gathering will be subject to the Open Meetings Act if a quorum of the members is present and the members either engage in discussion about the board or committee business or take formal action. So there's some key points to remember. So always be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present. Do not engage in discussion relating to board or committee business or policy when a quorum is present and you are outside of an officially noticed and scheduled meeting. And then keep in mind that violations can happen and do happen on social media. So that's something to be aware of. And then be aware of the walking quorum. And what is the walking quorum? So walking quorum occurs when fewer than a quorum of members engage in discussion about official business and they communicate this discussion to other members. While fewer than quorum of members participate in the initial communication, subsequent communication with other members will result in quorum discussing official business outside of public meetings. So an example of this would be a 5-member advisory board where 2 members privately engage in a phone call or an email expressing business. and then one of these members forwards the exchange to another member, this would be called in a walking quorum. So they would now be engaged in it. So engaging in small group discussions outside of properly noticed board meetings. So the best practices to avoid quorum issues. So members should avoid meeting in small groups, discussing board or committee business, and then communicating or forwarding these discussions to other members. And sending emails, do not send emails or text message to a quorum of members regarding official business, even if each email is addressed and sent to a particular member. And then also do not create posts on social media about board businesses where a likelihood exists that a quorum of members will participate in discussion. So Facebook, Twitter, retweeting, commenting on posts and such. So what, sorry, what are the guidelines for open session? So some of the guidelines for open sessions, the board or committee should limit its discussion on the specific terms that are found on the agenda. As previously mentioned, nothing that is not found on the agenda should be discussed in a formal way. There is a public comment section where the public is given the opportunity to speak, and the presiding officer is able to set reasonable limits on the public comments. And then if there is a subject that the members will wish to discuss that is not on the agenda, the members can propose to place the subject on the agenda for a future meeting. So those are the limitations for it. So there is civil penalties and civil remedies. So any interested person, including the media, may petition the court to stop action taken in violation of the Open Meetings Act. And the Open Meetings Act also specifically states that an action taken in violation of the act is voidable. There's also criminal penalties that can be given. Members who knowingly participate in, call, or aid in a calling of a meeting that is closed to the public are subject to criminal penalties, and these penalties range from a fine of $100 to $500, confinement in a county jail from 1 to 6 months, or both. So next, we're going to go over the Administrative Procedure Act, the APA. So the Administrative Procedure Act is known as the APA. It establishes the minimum standards of uniform practice and procedures for state agencies. It provides for public participation and transparency during the rulemaking process, and it governs the consented case process. The APA definition of a rule is any statement made by a state agency that either implements, interprets, prescribes laws or policies, or describes the procedure or practice requirements of a state agency. So there's different sources of this rulemaking: legislative changes, advisory board work groups, advisory board discussions, TDLR staff, the 4-year rule review, as well as rule petitions. And then we kind of have like a chart that goes over the administrative procedure of the rulemaking process. So first we start off with an idea for the rule. This rule is drafted and reviewed. This drafted rule is sent to the advisory board for consideration. And then the proposed rules are filed with the Texas Register. The public has 30 days to comment on the proposed rules. General counsel reviews, comments, and recommends any rule changes. The advisory board reviews, comments, and makes recommendations to the commission. The commission reviews rules, filing comments and recommendation, and adopts these rules. An adoption is filed with the Texas Register, and then rules become effective 20 days after filing. And something that's very important in this rulemaking process, the blue shows where the commission can give feedback. And we also want to point out that part of this process is to receive adequate feedback, and we really much appreciate it. So these blue boxes are 2 ways that that the advisory board can see the rules, make comments, and then it moves on to commission. Okay, next we have the Public Information Act. So the Public Information Act, also known as Open Records Act, is intended to allow each person information about the affairs of the government and the official act of public officials and employees. Sorry. The act makes all documents, records, and other information related to official business open to the public with some exceptions. Public information includes any electronic communication created, transmitted, received, or maintained on any device if it's concerning official business. This act should be construed liberally in favor of granting requests for information. So the open records process, first requests are received. If you get any of these requests, please forward them to the program attorney or the advisory board because there is certain deadlines that need to be met. Then when this is forwarded, general counsel requests information from you, please respond as soon as possible. There needs to be a prompt response, approximately 10 days. And you cannot ask why someone wants this information or these records. You can only ask for clarification. There is exceptions to disclosure, certain personal information such as date of birth, personal emails, medical information. Okay, and I believe this is the end of it. So some things that you should keep in mind from this training is know what a quorum is, be on the lookout for it always, be careful where you are and what is being discussed when there is a quorum present, know what the rulemaking process is like and what the role is, and engage, and also know that engaging in board communication on any device can be disclosed to the public if requested. If you guys have any questions, thank you for your time.
Okay, does anyone have any questions for Ms. Vella? Okay, if not, we're going to move on to item D, approval of the minutes for the meeting of June 30th of 2021. And I would ask Ms. Delia Luna to, does anybody have any questions? I'm sorry, on the, or comments on the previous meeting minutes that have been provided in the information package sent out?
No, do you need a motion to accept?
Yes, we do, if there are no questions.
I'll make that motion.
Okay, can we get a second?
Dave Yelovic, second.
Okay. And Ms. Delia Luna, can you do a roll call vote?
Yes, sir. James Graves,
I
Dave
guess,
Yelovic,
yes.
Yes. Aye.
David Morris, okay. Suzanne Smith,
Aye.
and Jerry Bittner, the presiding officer.
Aye.
Motion passes. Thank you.
Okay, moving forward, there is one public comment, respect to lists that pop up later. And it is an affirmative comment that supports the agenda item that's coming up later. It is by the Texas Air Conditioning Contractors Association. It just simply says it supports the following proposed amendment to Article 75, 100A5 of the Administrative Code. I don't know that we need to do anything further with that.
Not with that one, presiding officer. That public comment was submitted as a written public comment. It is available, and you provided the gist, which was actually extra. So as we know, we don't, we just allow that time for the public commenter to express themselves. And the only questions that could have been asked would be clarifying questions, but I don't think there was really any question left about that affirmative comment. So we are good.
Very good. So with that, we'll move on then to item F1, staff reports. And we'll get into the licensing division. And for that, we'll go to Miss Lisa Hudak.
Good morning, Chairman and board members. I'm Lisa Hodek, the licensing manager. I have presented you with the totals for fiscal year 21 and parts of fiscal year 2022, which is September 2021 to April. As you can see, the air conditioning contractors, the total population is already at 17,705. And last fiscal year, we were at 17,399. So we're definitely seeing an increase there. The registered technicians, we're also showing an increase. Total population currently is 29,290. Last fiscal year, it was 28,454. Certified technicians, we have a decrease. As you know, when the last law change, there are some differences now for the certified technician registrations. And our current population is at 4,334. Total combined, we are at 51,329 for all of the air conditioning license types, registrations, and certifications. That pretty much concludes my report. It was brief, but I'll be happy to answer any questions that you may have.
Lisa, I know in one of our other presentations or one of our other meetings, you had presented how many people had taken the test and how many had passed. I think it was a real low percentage that had passed. I was just curious if you had that information.
I think Rebecca will be sharing that information with you. That's part of the exam and education report.
Okay.
So I'm sure she'll have that for you shortly.
And for the record, that question came from Jimmy Graves. Okay, are there any other questions or comments then to the licensing division report?
Thank you.
Okay. If not, we'll move on to the customer service division. And for that, we'll move to Miss Mary Winston.
Good morning, Mary Winston again. Don Robinson, manager in customer service, was not able to be here. So I'm pinch hitting. And in pinch hitting, I can read those numbers for you, and we can tell that we have more phone calls here than emails. And those are contacts made to customer service in reference to your profession. It looks like a pretty steady flow. And for those times where there's a lower number or a higher number, I can reach back into customer service and request more information from Dawn. But as you can see, we have a pretty steady flow with the last reported month of April, which is the last full month that was reported, with over 2,000 calls and just under 200 emails, for a total of about 2,400 contacts made to customer service with questions during that time period. So if you have any questions for Dawn or customer service, I will gladly bring them back for her. Thank you.
Okay. Any questions of the members for that report? If not, we'll move on to item F3, the enforcement division, and for that, we'll move to Ms. Amanda Barrera.
Good morning, board members. My name is Amanda Barrera, and I'm a prosecutor in the Enforcement Division. As you can see in your materials, we had several promotions and a retirement, so congratulations to everyone. Moving on to our statistics, there appears to be a typo in your materials from pages 1 to 4 that lists fiscal year 2021. However, today we'll be discussing fiscal year 2022 through April. In the ACR program, we've received about 2,100 complaints. These numbers reflect all the complaints received by the department in this program before they're actually opened or reviewed by a prosecutor. Under our performance measures here, we opened 456 cases and about 7,400 for the agency as a whole. We closed 738 cases in the ACR program and 7,325 for the department. So this equates to about 10% of all the cases closed are in this ACR program. The average time to close was about 330 days, and we resolved about 40% of the cases within 6 months. About 9% of the cases resulted in disciplinary action, and we had 457 cases pending at the end of April. If you look at the next pie graph, you can see a breakdown of where the open cases came from once they're received by our intake department. 63% were consumer-related cases, 3% were departmental, and 34% of those cases were criminal history cases. Next, we'll discuss the case outcomes. We had one case that actually had a issued commission order, 31 default orders, and 35 agreed orders. For the program as a whole, we assessed $176,000 in penalties, and we were able to collect $60,000. We revoked 1 license and denied or revoked 8 licenses for criminal history reasons. We sent out 1 cease and desist and informally resolved about 670 cases. We were able to negotiate about $49,109.80 in consumer restitution, which is nearly a third of all the restitution negotiated by the department. So a third of that stems from this program. Next, you can see the trends of consumer cases specifically. We received 560 consumer complaints and opened about 280 cases. We informally resolved 464 consumer complaints. We issued 55 NOAVs, and 54 consumer cases resulted in disciplinary action. Usually, this graph is more of a funnel effect. However, you can see here that we kind of resolved more cases than we opened. I think this could be attributed to our whole team's effort and are achieving more experience and knowledge in this program. So we've been able to work faster and more efficiently and work some of the backlog that we had from fiscal year 2021. Next, we have our top violations at opening for fiscal year 2022 through April. These numbers again reflect the allegations listed in the complaint when the case is first open. So as you can see, our top 3 violations are criminal history, mechanical integrity issues, and unlicensed activity. However, our top violation that results in disciplinary action is pretty consistent in every meeting. It's usually contracting without a license and mechanical integrity issues. So in your material, beginning at the bottom of page 4 here, that's what it begins fiscal year 2021, which I did present at the last meeting. So I'm going to go ahead and move forward to the case highlights. Our first case is regarding Mr. Javier Linares, who was found to have intentionally or knowingly misrepresent a service that had been provided when he entered into a contract to install a 4-ton HVAC unit, but instead installed a 3.5-ton unit. Additionally, Mr. Linares did not have the proper endorsement to install that unit at the residence. A default order in the amount of $6,000 was entered against him. I will note Mr. Linares' license has expired, so he will be required to pay that penalty in order to renew his license. The next case is against Mr. Anthony Darrow. Mr. Darrow installed a 4-ton air handler in an HVAC unit without an appropriate license. A default order in the amount of $4,000 was entered against him. However, Mr. Darrow did contact the department and has paid his penalty in full. The next case is regarding Mr. Marino Lugo Jr., whose registration was revoked by operation of law. Mr. Lugo renewed his registration. It was discovered during his criminal history review that Mr. Lugo was imprisoned, and therefore on March 25th, 2020, his registration was automatically revoked by operation of law, and the department's renewal was invalid. However, I will note on March 30th of 2022, Mr. Lugo submitted a new application showing that he had been released from prison, and Mr. Lugo's criminal history was reviewed and confirmed that he was eligible to obtain a new registration. Next, we have another unlicensed case, Mr. Claudia Brannon, who had a default order entered against him for $4,000, and his registered air conditioning refrigeration technician registration was revoked when he contracted without a contractor's license. Lastly, we have Mr. David Boyce, who accepted liability for failing to perform a manual J heat load calculation at a job site prior to installing a new system. Mr. Boyce was assessed an administrative penalty of $3,000 and agreed to complete 8 additional hours of continuing education. Mr. Boyce has complied with the terms of the agreement. And so that's all I have for you today. I'm happy to answer any questions you may have.
Hi there, Dave Yelovic. I was just kind of curious, going way back to the top there. Did you say the average time to remedy a case was basically a year?
We closed the cases, I believe it was
330
330 days. Yes, sir.
Is there a reason? I mean, if I was a consumer,
Sure.
there would be some incredible memes on Facebook about how quickly we get things done here. Is there a reason?
Yes, I mean, this program is very technical in nature, and it's a little complex at the same time, and so it makes it a little more complex at every step. You know, the intake department reviewing and trying to obtain the evidence to see if we have jurisdiction and what the basic facts are. Investigations having to ask more technical questions, get more opportunities to talk to respondents, making sure that it goes to our experts to obtain expert opinions and materials, allowing the respondent again to respond to the expert's opinions. Due to its complexity, it also makes our legal analysis a little more difficult to, review the reports, the expert reports, determining all those things, which then makes negotiating a little more complex and trying those cases a little more complex to just make sure that we have, all the evidence to prove each and every one of those allegations, and are able to proficiently explain that to a judge and make sure that they understand those technical things. Most of our cases surround mechanical integrity and unlicensed activity. So, it takes a little bit more digging. It takes a little bit more time to try and contact respondents, especially when they're unlicensed. Sometimes it's a little bit of a find. So it just takes a little bit more more effort in these cases to make sure that we can get all that information in these types of
Okay.
cases.
I appreciate that. I would challenge folks to say, hey, there's a lot of stuff we can do in less than a year. I mean, I've dealt with FEMA many times on disaster stuff, and if I can get stuff done in 3 or 4 months using FEMA, I would just urge us, have some goals, some goals set for the next year, saying, hey, can we cut this down maybe to, I don't know, 240 days or something. But again, if we're a consumer-oriented group, we need to focus on getting, if people complain, they want resolution quickly, and having to wait a year for resolution, just as a consumer, I'm just saying that seems like a long time.
Absolutely. And there is about 40% that are resolved within 6 months. And so there is, that other percentage that's not, and those are usually the more complex cases, like I mentioned. And it just takes time to get everybody and all the parties to give us their stories and all the evidentiary issues that we may have in these cases.
All righty. Thank you, Amanda. I
Mhm.
do have a question for Doug. Doug, are you still on here somewhere?
Yes, sir, I am.
I saw, I think I read, you flew by there, it said we had one cease and desist order. And I was just curious, those seem kind of rare. And I was just thinking in a state as big as Texas, there's probably lots of guys running around doing unlicensed work and doing all sorts of shady stuff. Is one cease and desist letter weird, or is that just a low number?
I believe it's a low number. We have in the past few years started taking a shift toward trying to obtain cease and desist orders going into court. And I think the simplest explanation is we've encountered some resistance from the courts in getting these orders through, unless there is a situation where imminent harm is threatened, where a consumer's safety, where a system has contributed to an illness or injury of a consumer. And so we have encountered some resistance. We've gotten help from the Office of the Attorney General trying to push these forward. And I think the simplest answer is we have gotten resistance. And so we really have to reserve these for the worst of the worst, even though I think our preference would be whenever we have a repeat offender, especially with unlicensed activity, we would love to be able to prevent that person from operating and to put a potential criminal sanction over their head. And if the courts want to start lessening their resistance, I think we'd be happy to do that.
All righty. Thanks, Doug.
Thank you.
Mr. Yelovic, I wanted to add, and Amanda, thank you so much that, and I guess I'm saying this, Mary Winston TDLR, because I came here as a prosecutor, and of course that's always our goal, is to decrease that time frame. And as Amanda noted so well, part of this time is if we have unlicensed folks, we still have to afford them that due process of trying to reach out to them and get a response. So there are certain timelines that are put into place that make those cases longer. We do have experts that look at our technical things, but when we're dealing with the public, we don't have people sometimes, particularly the unlicensed folks, who want to cooperate, and but we still have to provide them that time. And so that pushes that number of days up quite a bit. So I just wanted to kind of add that in there.
And I would add as well, a lot of these cases too, we offer an opportunity for the respondent to fix the issues or to provide restitution. And so that takes some time for the parties to kind of come together and figure out a resolution between themselves. And we tend to try and encourage that and work together, and that may take some time as well.
All right. Thank you both.
Cherry Bittner, I'm just curious, when you noted what I thought was a significant number of negotiated settlements, and I was curious as to how that might factor in to the settlement timelines. It would seem to me that when the department is able to obtain negotiated settlements, that those are probably done on a significantly reduced time frame. Do you comment there?
That really does vary. Sometimes it's just a little more difficult to get the parties to communicate. It really just kind of varies on their availability and their willingness to do so. But we definitely do everything we can to try and obtain what we can for consumers, especially if there's consumer harm. Um, but it is a significant number. I'm proud to say that we were able to negotiate that for consumers. And sometimes it really does vary on how long it can take to get that done or not.
Thank you. So, any other questions regarding Enforcement Division? Okay.
Thank you.
If not, let's move on to item F4, the Education and Examination Division. And we'll call on Ms. Rebecca Adamus for that report.
Good morning, Chair and Advisory Board members. My name is Rebecca Adamus, and I'm with the Education and Examination Division, and I'll be providing you some statistical report for us today. The first page that you see in front of you is total as a whole, how all of the exams are performing. They are hovering as consistent as last fiscal year to this fiscal year at around the 40% range. The next page, if I could get them to scroll on to the next page, breaks it down by examination specifically. So this is where you will see how each exam is performing. We've got, environmental A, first part of the fiscal year, they were at 38, jumped up to 43, and then they're kind of leveling off at 36%. The other thing that I wanted to mention is, what will make it fluctuate is also the attempts at the examination, so that will kind of skew numbers as far as how many folks we have, the population taking the examination. So at this time, they are roughly about the same. I don't see a significant change in any way or another, like what, if anything is affecting that. They're pretty much consistent on how our examinations have been performing on the regular. If you could scroll a little further, a little more. The next page here is our continuing education courses, how many of our team has approved. You'll see that the numbers also fluctuate there. The reason being is at the time that the reports are run, it could be that some haven't been renewed, some have expired, and then that kind of also causes the fluctuation in the numbers that you see in front of you. And lastly, I just wanted to also just mention that we did have an exam review session where we meet with our third-party vendor and we review items to see how they're performing, whether they're performing poorly, they're performing well, and also augment items for our item pool to make sure that we, can ensure exam security. And I'm happy to answer any questions that you have.
Is any questions for Ms. Parada? If not, we'll move on to item F5, which is the regulatory program management. And for that, we'll move to Mr. William Weatherly.
Good morning, board members. Bill Weatherly. I'm the Air Conditioning and Refrigeration Chief Inspector and Program Specialist. I'm going to start with personnel updates. We have a new employee and my assistant. I'm very excited about that. AC Program Specialist 4, Troy Smart, came on board in January of this year. Troy was formerly the lead field service technician for Mechanical and Process Systems, MPS, in Austin. MPS is a commercial mechanical contracting and plumbing business in Central Texas. Troy has over 30 years experience in the HVAC industry, including residential, commercial, and industrial systems. He has already been a tremendous asset in helping eliminate our enforcement review backlog, and I am more than pleased to have him as a major part of our team. So I'm going to introduce Troy and let him come on and say a few words if he'd like. So go ahead, Troy.
Good morning, everybody. My name is Troy Smart, and like Bill said, I came from MPS. I worked with Bill Weatherly a long time ago at Johnson Controls back in the early 90s, and we also worked together over at Wattinger Service Company for quite a long time. And I guess about 2 years ago, Bill asked me if I wanted to come over to TDLR, and then the pandemic happened, and then the position opened up again. And I decided to come over here and not drag compressors across the roof anymore. So thank you for having me. Thank you.
Welcome.
Thank you, Troy. I just want to reiterate again, Troy is a tremendous help. His field experience and technical acumen is just exactly what we needed. So going into some highlights and activity, public outreach. I was a guest speaker at TACA 2021. They called it ACL, Air Conditioning Live. I thought that was kind of cute. But anyway, that conference was held in October. I conducted a session entitled Law and Rules. I think that's not in your notes there, but it was entitled Law and Rules. During this 3-day conference, attendees holding a Texas ACR license could satisfy their 8 hours of continuing education by attending the required breakout sections, including the law and rules. My session on law and rules was the last day, and they had to get that signed off in order to get their 8 hours. So I had a big audience. They had to come see me. So also, as Rebecca said earlier, we had an ACR exam review May the 10th, 11th, and 12th. Consisted of RPM, which myself and Rebecca Armas, our contractor PSI Gina, who leads the session, and our industry SMEs, made up of local contractor, some local, not local, but Texas-wide trainers, and we had a tremendous amount of experience in there. During the review sessions, exam questions were reviewed and scored to a set of parameters where the computer would pick them up for test questions. If the results of a test question, only 10% passed it before, it won't be picked up, or if 99% passed it, it won't be. So some of the questions we had to tweak a bit. I also introduced a newer version of Manual J, and we put that in our resources on our PSI exam. We have a candidate information bulletin. Now, we did that because the older version, you just can't find it anymore. So the newer version is the 2.5 2016 version, which is available. There was a little bit of difference in the two, so we reviewed all the questions that had anything to do with Manual J and made sure that they lined up with the new manual. We also needed some new exam questions for certain areas, especially for the certified technician. And we developed these questions, checked the references, identified them to their relevant exams. Going to industry updates. The first thing on here is the 2020 National Electric Code. Now, we're going to talk about this later, and it's going to come up for review. So I'm just going to hold that, until the next. I think Doug Jennings is going to talk about that, and I'll be here to answer questions as well. And then something in the industry I'd like to talk about. If you thought we were done with phasing out refrigerant, sorry guys, we're not. Right now the most common refrigerant for especially residential and some commercial applications is R410A. And we got to R410A because it had a low ozone depletion percentage. In other words, it did not deplete the ozone, and it obviously must have worked because, we started this in the 90s. In 2010, there was no more R410 allowed to be manufactured, and the industry couldn't sell 410A equipment. And from what I hear and what I read, the ozone hole has actually closed up a bit. So maybe it worked. But now here we go. In 2016, the United Nations Kigali Amendment to the Montreal Protocol is focusing on global warming potential. Unfortunately, 410A has a high global warming potential. So in January 2023, begins the transition and phase out of R410A as a refrigerant in new residential and commercial heating and air conditioning systems. There are two contenders to replace R410A, that's R32 and R454B. It'll be one of the two or maybe both. Each of these refrigerants has a much lower global warming coefficient that meets the requirements of the Kigali Amendment. The problem is that both the refrigerants are classified as mildly flammable. That would be they're classified as A2L, which means mildly flammable. Currently, the building codes do not allow for flammable refrigerants in residential applications and will have to be adjusted for the new refrigerants. It appears that the building code updates will not be available before the 2024 update release. Due to a lag in this code updates, the actual date of the phase out varies by state and implementation time, allowing for the building codes to catch up with rapidly changing requirements.
Hey, Bill.
Another issue at the time. Yes, sir. Go ahead.
This is Jimmy Graves. Those two refrigerants you mentioned, those are drop-in replacements for 410, aren't they? You don't have to replace the equipment.
Well, no, they're not. They have different characteristics. They have a higher, they're going to be higher pressures. The equipment has to be remanufactured for those. It's not a drop-in. Now, they do use the polyester oil rather than the mineral oil. So there is that. Okay. R32 is a single. It doesn't have a glide. So with with 410A, you have to introduce it when you're recharging a machine. It has to be the liquid only. It can't be the gas, because you can get a glide, and then you get your refrigerant pressures, are not as they should be, and you don't have good performance. But unfortunately, Jenny, from what I've seen, what I've talked to in the industry, they're not a drop-in. So there's going to be a problem there. There's going to also have to be some retraining for the technicians. So you can't use the same gauges because they are now. We'll emphasize they're mildly flammable, and what they say by that, I've understood, is that they are flammable, but if you put a torch to it, they won't maintain the flame. They are flammable, and so they have to be listed that way. So. But if you've heard they're a drop-in, that's new to me, Jimmy. That's not
I'll do some research on that.
Good. Go ahead. We do need some research, all right, because this is going to be a big change here.
Hey, Bill, Dave Yelovic here.
Yeah, go ahead, Dave.
Are these new refrigerants going to align with this new SEER 2 rating system that they're coming out with in 2023?
I believe they will, because from what I've heard, they are very efficient, especially R32. I mean, they're very efficient, and there won't be a drop in efficiency, over a 410A. So I am fairly confident that they will be.
All right, thanks.
You bet.
Bill, this is Jerry Bittner. Is it, it seems to be, based on what I'm reading here, a foregone conclusion that the building codes will be modified to allow the mildly flammable refrigerant. Does that seem to be the case?
That seems to be the case, everyone I've talked to. And I've talked to folks at Daikin, I've talked to folks at Train, and they're of course very much involved in it because they make the equipment. So yes, it's coming down. We've adopted the Kigali Amendment, and that's foregone conclusion that something has to change. And now, can I guarantee that it'll be these two? Can't, but that's what the industry is starting to standardize on. And so I think you can pretty much bet the farm on it.
Okay, thank you.
No, you're very welcome. It's yeah, I mean, I'm still learning myself on this, and I appreciate Jimmy. If you look into this and find out that it's a drop-in, I sure would like to know about that, because I get questions all the time about it.
Okay, I already found out. It's they are not drop-ins.
Okay, I didn't think they were. Yeah. But thanks for that. That was quick, Jimmy. Yay, internet.
Ask.
Okay, very good. Very good. Okay. At the time of this writing, the major HVAC brands in the United States differ on which refrigerants they will be offering. Presently, the direction is that Daikin, which is the largest manufacturer in the world, by the way, right now, Goodman, Lennox are leaning toward R32, while Johnson Controls, Carrier, Rheem, and Train are leaning toward 554B. This means that your service and repair technician will need to handle at least 3 refrigerants and maybe more on their vans in the next few years, at least a R410A, R432, 454B, R32, and if there are any R22 left out there, there's still a few left. Have to handle those. So they'll have to have different gauges for those and have some training. And so here we go. It's to be seen how well this comes about. So I'll open it up for more questions if anybody has any more. Always fun in the air conditioning industry. Well, that's all I've got.
Okay, any more questions popping up? So with that, let's go ahead and move on then to the Executive Office report And for that, we'll move to Ms. Murray Winston.
Thank you, Presiding Officer Bittner, and thank you, Bill, for educating us. Um, This is a very technical field, and some of the lay people have no idea what you're talking about. But please know that this is for the betterment of your system, as well as global warming, the ozone, so forth and so on. That was very informative. Thank you so much. RPM does a fantastic job. So, personnel updates. Since the last time we met, we have a new executive director. Our former executive director, Mr. Brian Francis, retired in January of this year. Appointed and hired to take over that position is former chair of our commission. So he sat on one side of the table, and then he came in on the other side of the table and worked as a deputy executive director. That is our new executive director, Mr. Mike Aris-Mendez. He took over on February 1, and we're so happy to have him. Secondly, we have two deputy executive directors. We have Mr. David Gonzalez. I believe everyone is familiar with David here. He used to be the director of RPM, and so he handled much of the technical work, as well as Ms. Christina Kaiser, who's our senior deputy executive director, who was formerly the director of our enforcement division. Both David and Christina have, I know, well over 20 years with the agency, and many of those in leadership positions. So we welcome them to those positions. Rounding out our executive office, we have Mr. Hemant Macon. We got Hemant when we got podiatry. Hemant Macon, new chief of staff, was formerly the executive director of the podiatry board. When we were gifted that program by the legislature, we were honored that we could get him hired on as part of TDLR's team. Him now is our chief of staff, and we welcome him as well. That rounds out our new hires in the executive office. Sunset and strategic planning update. I think we've probably said this to you before. I know we have, and we've said it in many meetings. We went through our sunset review. That means our sunset staff came forward and they were with us, I think, about a year. They went through everything, our processes, our procedures, our documents, how we do things. Sunset Commission is a commission that looks into all state agencies, and they determine if that agency should continue, i.e., is it doing the work it should do? Does it need to improve? What does it need to improve? The ultimate gold seal from Sunset is a 12-year continuance. I'm happy to say that TDLR did achieve that goal. They came in, they told us some good things, and they told us many things that we needed to review and that we needed to improve on. And we were really happy in receiving that information, and we're currently working on those improvements right now. So, but we did also achieve that gold seal, that gold standard of you're doing a good job. So continue to do it. That means our next review would be set in 12 years. Strategic planning. We just completed our strategic planning and issued the report. So we do strategic planning a little bit differently here. At TDLR, we do surveys, we do ask stakeholders, but we also go out into the public and we want to speak with those stakeholders directly. We know that we sit in our offices in Austin or wherever we're stationed, and we do the best we can with pen and paper. We also rely quite heavily on this advisory board to let us know what's going on in the industry. During strategic planning, we send out contingencies into different cities, and we ask, what can we do better? What are we doing well? What new is coming up in your industry? Those are main questions that we ask. And we receive that information and we make that part of our planning for the next several years. The report for our strategic plan is on our website. It's not very long, over 20 pages, but it is good reading and it lets you know where the agency is heading for the next several years. So, lastly, I want to talk about our communication outreach. our informal sort of documentation of how our web presence is doing for your dedicated web page. We have almost 200,000 views within a 6-month period ending mid-May, with over 1,000 views per day. Most folks are viewing that from the desktop and 60% from a smartphone, which means that folks are on the move and they're checking that website out when they can, which is by that smartphone. And I'm glad we have it available. We still have about a 1% that does view the website from a tablet. Main reasons for visiting the site: how to apply for a contractor license, exam information, how to apply for a technician certification, they're looking for forms, and finally, how to apply for a technician registration. So that lets our folks know and our webmaster know that the information that is being included on the website is valid and helpful to the public and the stakeholders and the licensees. That wraps up my report. If you have any questions, please let me know. Thank you so much.
Okay, if there are no questions for Ms. Winston, we'll go ahead and move on to item G of our agenda, which is the discussion and possible recommendation on the proposed amendment to an existing rule. And for that, I'll call on Mr. Doug Jennings to explain what's going on, why the modification of the rule is up for discussion, and then we'll see if we can move that forward.
Thank you, Presiding Officer Bittner. Again, I'm Doug Jennings, Assistant General Counsel for the department. Long-term board members and staff can be forgiven for that feeling of deja vu you may be having right now. Again, discussing application of Section 210.8F of the National Electrical Code, the 2020 version. Just a quick recap. That section of the 2020 NEC requires certain outdoor outlets to have GFCI protection. And one of the unintended consequences of implementing 210.8F is tripping of circuit breakers, which renders air conditioning and heating systems. It causes nuisance tripping, causes those systems to become inoperable. There has been a lot of discussion about this issue at the state level. There's been a lot of discussion at this issue at the NFPA, the organization that administers and puts together the NEC. There's a couple of pending amendments, temporary amendments to the 2020 NEC right now at the NFPA, trying to push implementation of Section 210.8F off to 2026. Our Chief Electrical Inspector, Jerry Daniel, informed me, and we did some research, that the vast majority of the states that have adopted the 2020 NEC have recognized this problem and have limited the application of Section 210.8F in some manner, some excluding it altogether, some limiting its implementation. So you may recall, new members you won't, but older members you will recall, last year we had a rulemaking to amend sections 75.100A5 of the Air Conditioning and Refrigeration Contractors Administrative Rules. And what we did, what the group decided to do, and which was ultimately adopted by our commission, was to push forward the implementation, the adoption of 210.8F until January 1st, 2023. And the hope was maybe by then the equipment manufacturers will have caught up, these equipment incompatibilities will be resolved. Unfortunately, that has not happened. And so our commission's belief and our program experts' belief is that allowing 210.8F to be adopted as part of the 2020 NEC does pose a danger to Texans due to the high temperatures we have in the summer and low temperatures in the winter. We want to make sure those systems are operating as intended. I will bring up the rule text. It's fairly simple. Let's see. So you will see this is Rule 75-100 as it currently stands. And so we'll scroll down to subsection A5. So the change that we're making here, you can see the struck text. We were just saying we would like to adopt this rule that says compliance with Section 210.8F of the 2020 National Electrical Code is not required, period. And so we're removing that until January 1st, 2023 language. And what this will do, we are going to start, as an agency, going to start looking at the 2023 NEC here at the beginning. It looks probably at the beginning of 2023, we'll start looking at adopting that. And I have a strong feeling that the language of 210.8F is going to be modified somewhat based on the discussion we're hearing from experts and the industry. So really, in essence, what we're asking is for your consideration to, to help ensure that systems remain operable in Texas, and we can look at this issue again in probably less than a year. We have Bill Weatherly on hand for technical questions. And if you'd like to ask those technical questions, I will definitely defer to Bill. But if you have any questions about the rules or the legalities, I'm happy to answer them.
Dave Yelovic, I think as the home builder guy in the group, I'll say that just simply crossing out those words at the end is a great idea. And going forward, I can tell you there are other things that are still in the code as a home builder, like electric dryer GFCIs, that are tripping all over the state. So the technology hasn't caught up by any means. So I like your idea of just striking the date and pushing this off to the next code. We can review it then, but this does at least get us out of the end of the year deadline.
Great. Thank you, Mr. Yelovic. Just a reminder again that we did have a comment from TACA in favor of this amendment. Just wanted to remind you of that. I'll just go ahead and say this. It looks like we may not have any more questions. The motion that we're asking for is for approval of the proposed rule, at which point we will publish the rule, wait for the 30-day comment period, then bring all of the comments back to this board for your consideration before we move further.
Dave Yelovic, I so move.
This is Jimmy Graves. I'll second.
Okay, that was very rapid. At this time, then we'll ask Ms. Delia Luna for a roll call vote.
Yes, sir. James Graves,
Aye.
Dave Yelovic,
Aye.
David Morris,
Aye.
Suzanne Smith,
Aye.
and Jerry Bittner, presiding officer.
Aye.
Motion passes.
Thank you all very much.
Okay, while we're with Mr. Jennings, we'll just move on. He's also going to talk about the appointment of a enforcement work group.
Yes, thank you, Presiding Officer Bittner. Again, Doug Jennings, Assistant General Counsel. Just wanted to ask your leave to set up a standing work group for enforcement-related matters. And if Ms. Barrera has anything to add, I'll invite her to speak. Generally, the way that we have handled work groups on this advisory board is on an ad hoc basis. Usually a specific issue will come up, we'll appoint a work group for that. And so for this, we would like to have a standing work group so that when issues come up, we can simply take them to the work group without having to have an advisory board meeting to appoint members for that ad hoc group. So Amanda, do you have anything to add? All right. So once again, Presiding Officer Bittner, we ask that we have at least 3, but no more than 4 members appointed to the group. Thank you.
Okay, well, with that having been said, I'm going to ask then, are there any volunteers to be on that standing work group?
David Morris here. I'd like to volunteer my time for that.
Okay. Any others? Okay.
An ex officio member, I would like to volunteer as well to be on the work group. This is Bill Weatherly.
All righty. That gives us 2. If there are no others, it looks like I'm going to need to appoint someone. So, and I know that Mr. Compion would be interested, but he's not here. So
You are free to appoint him in his absence. We
I
will
would-
let him know.
I would do that. I know Mr. Compion has a great deal of interest in the enforcement division. He's expressed that many times in the past. So I would appoint Mr. Compion as the third member of the standing committee.
And our ex officio member is not a voting member. So I just want to,
Do we need one more voting member?
we do.
Okay, then I would appoint Suzanne Smith.
Thank you.
All righty.
Presiding officer, may I go over the names again, just to make sure that we all have them correctly?
Yes, please.
We have David Morris, Dolores Compion, Suzanne Smith, and Bill Weatherly as the ex officio member.
That is correct as I have them written down.
Thank you.
Okay. Let's move on to then item I, which is recommendation for any agenda items for the next board meeting. Any of the members have any recommendations for specific agenda items? If we do, Ms. Luna can write them down and we can get them on the agenda for the next meeting.
This is Dave Yelovic. I mentioned early the new SEER 2 requirements going into effect at the beginning of the year. I think we might want to at least discuss it and be aware of what may or may not happen, because right now, most manufacturers I talk to are not geared up, and there's quite a possibility that many of you guys out there may not have units to set at the end of the year.
We can't get equipment now.
I know, it's going to get worse when they say, no, you can't sell this stuff anymore, period. And it all gets thrown in the big waste heap in the sky, I guess.
Yeah, Bill Weatherly, I'll jump in here too. I've talked to a lot of contractors about that, and the supply chain is not pretty right now. And what they're having to do, a lot of times, the homeowner will request a specific equipment, and if their equipment is down in the house, they can't get that, so they kind of have to go with what's available. So it will be a problem. And as I understand it, we'll be going from a standard of 14 SEER to 16 SEER. I mean, that may be simplifying it a little bit, but you know, there are just not that many made. I mean, it's
Right.
to fill the need, especially if we go to that.
And that's part of the predicament, me as a builder, if we advertise that we're top notch, we offer a minimum of SEER 16. No manufacturer right now can tell me what combination of equipment is going to give me that SEER rating. And we're just taking all reference to SEER ratings out of our marketing at the moment because nobody can tell us what's going on.
I don't blame you, Dave. That's horrible.
Yes, at all the air conditioning purveyors, is my experience as well. The pickings are slim.
Yeah. And then just education wise, there's probably many people who don't understand that this new standard is even coming. I mean, most of us on this call are kind of up to date on stuff, but what, 50% may not know this is coming?
A lot of contractors don't know this is coming.
Yeah.
Ones I've talked to. Yeah.
Yep. They say, well, isn't it just like SEER ratings now? No. So we may have to have a general discussion, and there may be some sort of education element.
Very good. We'll get that added to the agenda for next meeting. Anything else? Any other agenda items that any of the board members would like to introduce for discussion in the next meeting? Okay. If not, then we'll move on to item J, which is discussion of the date and time and location of the next board meeting. Debbie will pull the board at a later time with regard to this one. I think she has some ideas that she'll present to us at a certain time in the future.
Presiding officer, I do have Doug Jennings, if he will also come on board, but he does want to have a meeting in August. So we have some proposed dates. August 24th, that's on a Wednesday, or the 26th on a Friday.
Wednesdays always seem to be better than Fridays.
Yeah, this is Jimmy Graves. I'm good for either one of those days right now.
I am as well. I can work either of those 2 days. Yeah.
Mr. Morris
David
and
Morris here. I can agree. I'm available either the Wednesday or the Friday.
perfect. And Ms. Smith, are you okay with that date as well?
She is
Suzanne,
mute.
you're muted.
Yeah, if we can't get her, we can ask offline. Yeah, we can ask offline.
Yeah, sounds like a good start.
So let's go ahead and schedule it, if
Okay.
it's okay, for Wednesday, the 24th at 10 a.m.
Okay. All right.
Online again or in person?
online.
Very good. And my guess is you'll publish that and send it out officially to the board members.
Yes, sir, I will.
Okay, thank you.
Thank you.
Okay, if there is nothing else pending, then we will move to adjourn. I note the time is 11:22 a.m. on my computer clock. So with that, we'll call the meeting adjourned.
Thank you.
Gary.